Madam Chair, we are now live.
Well, good morning, members of the Senate Judiciary Committee. It's good to see you this morning. This meeting will officially begin. We will start with roll call.
Madam Chair, we are now live. Excuse me, let me.
Members of the Senate Judiciary Committee, it's good to see you this morning. This meeting will officially begin. We will start with roll call. For those of you that may be watching live on YouTube, if you would mute your YouTube or stop it for the members or anyone coming in, there'll be that feedback every time because the YouTube stream is slightly delayed compared
I apologize.
You're fine, Donna. Thank you so much. For the members coming in.
I apologize. I'm going to try and mute that, Madam Chair. Okay, I'm taking roll call. Senator Cooper.
Here.
Senator French.
Here.
Senator Kolb.
Here.
Senator Cost.
Present.
Chairman Nethercott.
Here. Well, thank you, Ms. Shippen. Good committee members and members of the public. You'll see that we do have the fortune of being staffed by LSO, Ms. Donna Shippen, and she'll be walking us through this morning. As a reminder for members of the public and the committee, we have not done these types of standing committee meetings before via Zoom, and so this is kind of new for the legislature and new for our staff. And good news is we have plenty of time this morning. As you know, we will not be gaveling in until 1 o'clock this afternoon, as compared to a regular session where we would be gaveling in at 10 a.m. So we have the luxury of a little bit more time to work these bills, although I don't know that that's necessary, but it certainly is good to know and good to have. Any introductory comments from the good members of the Senate Judiciary Committee? All right, seeing none, we will start with the first bill, House Bill 34. And as a reminder, committee members and members of the public, these are the three bills that you see in front of us, or at least two of the bills, House Bill 34 and House Bill 35, are Joint Judiciary Committee sponsored bills that were worked in the interim by the Joint Judiciary Committee, the House and the Senate Judiciary Committees together. These bills were heard last week through House Judiciary Committee by itself and through Committee of the Whole of the House Chamber, and those bills passed out of the House of Representatives, and now it's our job as the Senate to work the bills in this committee and then pass it out to Committee of the Whole if that's what this committee chooses to do. So the other bill that was not a Joint Judiciary Committee bill is House Bill 42, and that's the Chancery Court Vacancy Amendments Bill. That bill was sponsored by the Blockchain Task Force Committee, of which I am also a member of and have served on for the last number of years. And so because of the subject matter of that bill and because it was appropriate for the Blockchain Committee Task Force to hear that bill, but the Blockchain Committee Task Force is not a standing committee. And so it needs to go through this committee in order to come out to Committee of the Whole. And so that's why there's a difference there with that particular bill. And I can explain more as we go through it. But these are the bills that have passed out of the House chamber. So with that, we'll look at House Bill 34, Youthful Offender Program Amendments. And I don't know why my links are not working. Good Senator Cost, do you want to walk us through this good little bill since you heard about it through the interim?
Sure, I'd be happy to. We'll start out with House Bill 34, Youthful Offender Program Amendments. This is a bill relating to youthful offender programs and amending the program so that eligibility requirements and programming emphasis authorizing the use of peer specialists, providing a definition and providing for an effective date. What this really is doing is saying that they're trying an alternative way of working with some of these youth and the process, and hopefully simplifying some things and helping our youth as well. Section, as well as our other offenders Section 1 talks about Wyoming statute creating a new paragraph in 713.1001A, and that new paragraph is 2, and then we renumber what was 2 becomes 3, and then 713.1002A creates a new paragraph 1, and then the renumbering of the others to 2, 3, instead of just 1 and 2. And then I'm sorry, I said that wrong. The renumbering of 1, 2, and 3, moving them up. So section 713.1003A B becomes an intro with 2 by creating a new paragraph 4, and C gives us 1 and 2, and D are amended to read. And then down below on page 2, we have the youthful offender transition. Definitions: peer specialist. This is a long-term inmate who has completed certified training and been selected and assigned by the department to provide positive guided peer support to offenders involved in the program under the direction of the program staff, provided that peer specialists shall not have direct supervision over the other inmates. On line 14, the new 3 is reduction of the sentence, includes changing a sentence of incarceration to a grant of probation, and sentence in line 18, 713.1002, sentence reduction for youthful offenders. On 20 and 21, you'll notice it says the sentencing court may reduce the sentence of any convicted felon. And I wanted to emphasize may because may allows them the opportunity to make a decision on it, not forcing anything. On to page 3, on the 1 and 2 this is the new insert. It is recommended by the sentencing court for placement in the youthful offender transition program. And then of course, what used to be 1 becomes 2, and it's been also added transition program. So it says completed the youthful offender transition program. Then 3, on line 8, we've inserted application to the court for a reduction in sentence with 1 year after the individual begins serving the sentence of incarceration. We go on down. 13 talks about statute 713.1003, and line 16 is the paragraph A, where we've inserted again youthful offender. On line 17, it's youthful offender transition program. And if you go on down to page 4, we insert transition again, youthful offender transition program. And on line 4 and 5, it's been changed from 25 to 30 years and has not attained the age of 30 years of age. And then on line 7 through 10, the new IV4, I guess would be whichever way you want to call it, is able to participate in the structured programming, education, work, and physical fitness activities required of the program participants in compliance with the Americans with Disabilities Act. So that covers the ADA requirements. We move on down in 15 through 17. Inserted is separation of program participants from the general inmate population, except inmates assigned to work in the program as peer specialists. So this allows inmates to be able to work with these when they have been trained and certified as a peer specialist. On down to 19 through 21, emphasis on structured programming, education, work, and physical activity compliant with the American Disabilities Act as major elements of the program. And then we drop down to page 5, where once again they insert transition in the Youthful Offender Transition Program, stating that it is a matter of grace and not of right. Approval of an inmate's participation in the program may be revoked by the department at any time if the inmate fails to comply with program requirements. The inmate shall not have any right to appeal the denial of his participation in the program. So basically, this just allows the program and allows inmates to be able to be part of the program. It's called the Youthful Offender Transition Program. And with that quick explanation, I would open it to any questions for somebody who may want to have one.
Thank you, Senator Cost. That was very helpful and a good reminder of the work we did in the interim, kind of the big picture perspective, committee members, for what this bill does. This bill, you may have formerly heard of the boot camp program. Nod your heads if you've heard of the boot camp program. Yeah, that was a program through the Wyoming Department of Corrections that allowed for offenders or defendants who had been sentenced to a prison term between the ages of 18 and 25 to, instead of going to Rollins or some other DOC facility, they went to a boot camp program, which was a DOC facility too, but it was more of a program structured to instill, physical fitness and discipline and values. And as a result of recent litigation that you may have heard about in recent years, the Department of Corrections was sued by a female inmate who wanted to go into the program, but of course couldn't because the program was limited to males. The court found that she did have a right to do that, and so the program needs to be expanded. They changed it from the boot camp program to Youthful Offender Program. They have found that that's actually more effective across the board and results in greater efficacy. We heard testimony in the interim from the Department of Corrections. Normally, we would have the Department of Corrections on board. They've had some leadership transition this past summer, so likely why they're not here with us this morning. But really, this program does two things. One, it allows females to be part of the program, changes the name of the program from the boot camp program to the Youthful Offender Program, and it expands the age limit from 25 to 30, and also allows for current prison inmates to work or volunteer in the program to serve as mentors, as you saw identified there. And that's really the purpose of the bill. And it was brought to us by the Department of Corrections as a need to update this particular law and program. So questions from the committee? Yeah, Senator French.
Yes, Madam Chair. For the newbie here, can you explain maybe the parameters of their eligibility? Somebody that's, I assume, somebody that's been convicted of capital murder or attempted murder or certain crimes would not be eligible, and certain crimes are?
Thank you, Senator French. Great question. There are no limitations, I don't believe, on the program for the type of crime being convicted. So generally, though, the program is intended to focus on those inmates who are receiving a sentence that will be out in a period of years, right? So it's not a capital sentence per se, where they have a life sentence. They wouldn't go to the boot camp because the boot camp is intended upon graduation, upon successful completion of then going out onto probation instead of completing a prison sentence. So it's kind of in lieu of that prison sentence. And it's this intense opportunity. Now, the Department of Corrections does screen their applicants to make sure that they are the right fit for the program. There are some physical fitness requirements associated. So somebody who may have some type of health condition that would not allow them to participate in the physical conditioning may not qualify. Someone with severe substance abuse issues that might need the intensive treatment unit more so than the boot camp program. And some violent offenders may not be appropriate either, but my understanding and my recollection is that even someone charged with or convicted of, these are felons who have been convicted. It's not misdemeanors, it's felonies of, let's say, involuntary manslaughter. They can go, or even second degree. And what is a crime that looks like that? So a DUI resulting in a homicide, or you have two 21-year-olds out joyriding and they're going 110 miles an hour and wreck, kills their passengers or kills an innocent party. That's still homicide, just not necessarily the way that we might think of it. And instead of sending them to the penitentiary, they might go to boot camp. Yes, Senator French.
One more, if I may, Madam Chair. What are the consequences if they're in the program and they're granted a probation or a reduction of their sentence, and they, for lack of a better term, mess up when they have been granted that special condition? Do they go back to their original sentence, or is there an additional penalty for making it into this and then violating whatever part of it?
Yeah, thank you, Senator French. It depends on when that violation occurs. So if they fail the program for whatever reason, they're going to go back and do that underlying sentence. So let's say they got 3 to 5 years in prison. They flunk out the first 3 months of the boot camp program or 2 months. They're just going to go straight to Rollins and start serving their time there, and that opportunity is ended. If they graduate the program and then are out on probation for a period of years and they violate probation, it just depends on what the judge chooses to do in relationship to that violation of that probationary term. So it might be a minor infraction, or it could be something more significant, and it just is weighted upon the significance of the infraction. Yes, Senator Cooper.
I happen to know a young man who's been through this program, and it was very beneficial to him. He came out, he's got his life going the right direction, very protective member of society, taking care of his family. So it's my understanding that what this bill does is just to take some inmates from Rollins and bring them to the youthful offender facility and use them to mentor the kids, the young men or women, as they are going through this program. Is that correct?
Senator Cooper, that is one purpose of the bill. There are many others, but that is one certain characteristic that is substantive with the bill, yes. So it does allow those inmates to be mentors. Senator Kolb.
Thank you, Madam Chairman. Why weren't women included in the beginning of this proposed, boot camp or whatever we may be calling it today? What was the background on that? Thank you.
Thank you, Senator Kolb. I can't speak to the specifics of it. I do see someone, I think our interim director of the Department of Corrections is here, and I'll let him in just a minute to speak. I appreciate Mr. Shannon being here. I don't know that there was an intention to exclude women. I think when you look at the history of inmate populations and the demographics of those defendants going into prison, the majority are males. The majority are males ages, 18 to 25. And so as a result of kind of different opportunities associated with deterrence and rehabilitation, boot camp programs, I think, were popular decades ago, and Wyoming took that up. Wyoming has a unique challenge for all things, including Department of Corrections, where we don't have an efficiency of scale either. So the costs associated with standing up a program are really expensive when we don't have a high volume of participants, right? Which is good for Wyoming. We don't necessarily want a high volume of participants in our correctional programs, but when we're looking at something that might have a deterrent or a rehabilitative effect, it gets costly to put it up. And so looking at the number of women who would benefit or probably be eligible for the program, it just didn't exist. In Wyoming and all prisons across the United States, we do have segregated by gender correctional institutions. And so men and women aren't housed together. So we have the women's prison up in Lusk, and the rest of our facilities are for men. But because this is a program that you have to get court approval for, it really is an opportunity to be fortunate enough to receive, to be accepted into the program. It's a little bit different than just where you get housed for a correctional institution. So that's why, you know, those same arguments associated with the boot camp program don't necessarily apply with the prison itself. That makes sense. Senator French?
Yes, one more thing, Madam Chair. Is there a benefit to those older inmates that have chosen to mentor the youthful ones to try to get their life back on track? Is there some kind of benefit to them?
Yes, Senator French, I think the answer to that is most definitely yes. I think they get value, of course, from being productive and being helpful and trying to make sure that what happened to them doesn't happen to someone else. The inmates do receive good time credit, and this I think would help, you know, support those calculations for good time and other type of commendations. So when they are eligible for parole, or when they may be looking at early release, that participation in these types of programs certainly is an asset for them, and you know, a bullet point on their resume essentially for the work that they've done while in their efforts to be rehabilitated. So with that, I'm going to bring in Director Shannon. He is coming in, so we'll see him, I think, appear here shortly. Director Shannon, if you're there, if you'd show your video.
Good morning, Madam Chair, members of the committee. I'm Dan Shannon, Director of the Department of Corrections. Thank you for having me this morning.
Director Shannon, great to see you. I hope I didn't butcher too many of the answers to those questions. I'll at least bought you a little bit of time to write them down and get through them. Are you formally, and forgive me for not knowing, the director? Are you still interim?
Madam Chair, became the permanent director in October. Thank you for asking.
Wonderful, congratulations. So Director Shannon is the director of the Department of Corrections, and so he will be a face that we see probably frequently and regularly during this session and during the interim. So Director Shannon, any follow-up or correcting of my answers regarding the Youthful Offender Program?
No, Madam Chair, very few. You did an excellent job presenting it, and I thank you for that. I know Senator Kolb asked the question, I'm sorry, not asked the question, were women excluded? And you answered it fairly close. Women were never excluded from the program, but they weren't able to participate within our own state. At that time, we've had, in the past 4 years, we've had 3 participants, and there were only 2 institutions available, Pennsylvania or Florida. And the women were not able to participate within our own state, so they were transported to the state of Florida to participate in the boot camp program. If I may, I could, for the committee, I could give a brief rundown if that would assist of how we got here today.
Please do, Director. I appreciate that.
Madam Chair, committee members, our past success at the boot camp hasn't been the best. We've had some wonderful outcomes, but also on our percentage base, we're roughly right around 48–50%, not much different than when we're releasing directly from the penitentiary. As I mentioned earlier, there's only 5 states left with boot camps, 3 for females and 2 that are co-ed. That leaves only 2 institutions, Pennsylvania and Florida, across the nation that still participate in this. The Department of Corrections, during the interim topic, wanted to take a different approach, but it's for a number of reasons. Not only for the usefulness, but also for the efficiency of the department. We want to produce a better product. We want our inmates to have better success, and also we need to realign. In July, we had inmates housed in Mississippi, Scottsbluff, Nebraska, in our own counties through Lincoln, Uinta, and Goshen County. All the inmates were returned. We have no more inmates housed out of our department, they're all within our state and within our department. It's my intent to address a number of issues with this move, and then I'll go into the programs, and I'd like to explain a few things as far as pure splashes, things of that nature. It's my intent, if this bill is supported and approved, to our highest number, we have a 64-bed unit in Newcastle. That's where our boot camp is. It's located inside our minimum facility. It's a medium facility located inside of our minimum facility. It's my intent to relocate that male facility, those individuals, to WSP in G unit. That is a 32-bed unit. I feel comfortable that would provide more than ample space to complete the program. So what would take place is male inmates would come to our intake facility at WMCI in Torrington. After appropriate classification, meeting the requirements, they would be transferred to WSP in Rawlins. There, it would be segregated. It would be the same, similar situation. They would be segregated from the adult inmates. They would be separated out. Our females are, in the past, we had approval to build an additional boot camp at Newcastle. That has since been canceled. Our females, our ladies, would be able to be classified and processed through the Women's Center in Lusk. They would be right on grounds. They would be produced in Hall 4. The ladies would not have to leave. They would not have to go out of state. They'd be able to continue with this program right here on grounds. Now that leaves a vacancy in Newcastle for that 64-bed unit. For years now, our highest contribution and contributing factor to the incarceration at the Women's Center has been food, drugs, and alcohol. We have a very good intensive treatment unit, but for years now, currently we have 103 ladies waiting to enter the program. It's a 9 to 12 month program. Now, if you think about that, with a 64-bed unit, 58-bed unit at the Women's Center, will never catch up. That creates a bottleneck, and it's just not appropriate. So it's my intent, then we're going to have a vacancy in Newcastle for the 64-bed unit, because those males that were currently there now will go to WSP. So what we'll do is we'll coincide a ITU program at the Women's Center, as well as the ladies will be housed at the ITU Center, will be where the boot camp in Newcastle is now. After one term of graduation, then all ladies who are prepared to go to the TC unit, the therapeutic community, will be relocated inside the facilities at Newcastle. Now that is quite a bit of a change, but really not for the department. Since 2010, we've been housing female offenders at our Torrington facilities. Our policies are accredited and sound. I myself have been a warden in a separate state for over 15 years where we house co-ed. I have no concerns with that. The ladies will not have interactions with our minimum facilities at Newcastle. So what will that produce? That'll produce a program that benefits our female offenders. They won't have to go out of state. Our female offenders who have been waiting for quite some time to receive substance abuse treatment will be right online and be treated similar to our males. We will not be housing inmates out of state, and we clearly have a much more efficient department. There are several things I would like to continue, if I may. I would like to talk about the peer specialist. In our House committees, there was concerns that, and rightfully so, there was concerns if our peer specialists would have any form of oversight or supervision of other inmates. Between the two programs, between the male and female programs, our youthful offender programs, the peer specialists, there would be a maximum of 4. So it'd probably be 2 and 2, 2 with the males and 2 with the females. These are long-term inmates who would be certified through a 40-hour program. I think it was Senator French that asked a question concerning what type of contribution will they get. These inmates will be vetted, nonviolent, minimum security inmates. And as the Madam Chair commented, there will be some reward as far as internal satisfaction. It will look beneficial when it comes time for parole, things of that nature. They won't be compensated. It'll be a program that the data has shown that it does assist in certain things. But I just wanted to reassure the committee, there'll be no oversight. They're not replacing correctional staff. They're not replacing supporter programming staffs. They will have no oversight. Our departmental policies for approximately the last 7 to 8 years have clearly identified no inmate will have oversight of another inmate. We've also asked the the adjustment to create the bill to raise the age from 25 to 30. And I just wanted to provide a few statistics. There are approximately 329 inmates incarcerated within our department now between the age of 25 and 30. So that'll provide also an increase of opportunities for the courts in alternative sentencing, which we strongly support. And we also have 176 inmates, 25 years of age and under. So with those numbers, it'll open up quite a bit of doors and provide more opportunities if appropriate and properly vetted. Current statistics have clearly shown that I think it's up to, anecdotally, it's the age 31 that the brain's still developing. And so I would like to provide support for that. That's why the age was increased from 25 to 30. Last thing in the bill, the program will clearly be disciplined. It'll be structured, but it's more on a cognitive base to really address what the youthful offenders' needs are, and it won't be such a military style intervention. There's also a change in the bill at the request of the Attorney General's office to review for ADA. So we're not going to exclude anyone from this program. We're going to ensure that we're going to be as successful as we can. We have a responsibility to our state to do so. Madam Chair, I'll stand for questions.
Questions for the director, Senator Kolb.
Thank you, Madam Chair. Director, I guess clarification on the recidivism rate for folks that went through, want to call it the boot camp program or the youthful offender program. What is the background on that?
Director.
Madam Chair, Senator Kolb, the exact numbers I can provide to committee, and I'll have it sent today. I can provide documentation for approximately the last 15 years. It's consistently, success rates were in the 60 percentile. For the last 4 or 5 years, they've gone down. We've even included drug and alcohol. We provide some programming changes, but currently it's around Senator Kolb, it's around 48% success rate. That is the same if we release an individual straight from our penitentiary and under supervision. I hope I answered your question.
Senator Kolb, any follow-up?
No, I'll look at the data. I just wondered the cost-benefit ratio for what we're doing, and is it? I guess I assume it's what you wish to move forward with at this point, Director. Thank you, Madam Chairman.
Director Shannon, the cost-benefit of corrections. Any thoughts?
Well, there's a number of cost benefits. The old adage, we have a saying of 95-5 in you, 95% of our inmates within 5 years will be living next to you. I have a responsibility to produce the best inmate we can to return to our communities. Some cost benefits alone, just this change alone, Madam Chair, I would address to Senator Kolb. We were paying in excess of $430,000 a month to house inmates out or return them home. The cost benefit I don't even know how you'd put this in account, that our female offenders are now getting treatment faster. The cost benefit that we don't ship our female inmates out of state. Local families can benefit by visiting. Now with this program, the Youthful Offender Program itself, we can accept what we have. I'll still, if this bill, Madam Chair, if this bill isn't passed, I will do everything I can to make it safely and efficient within our department. If the bill isn't passed, we know what the success rates are. And I'm data driven, and I have to rely on making what I believe that are appropriate cognitive based data changes to help improve the odds for our youthful people to return to our community. I hope that answered your question.
Thank you, Director. Any additional questions for the Director? All right, seeing none. Any final thoughts, Director Shannon? Appreciate you being here.
Madam Chair, committee members, it's been a pleasure to be here. If I could just bear one moment, to look over some notes here. No, I thank you for your consideration on this bill. As I mentioned earlier, I'm doing everything within my capabilities to ensure that we give our youth the individuals that have made mistakes and we removed them from society, we also have the responsibility now to return them back to society as a better individual, and that's what I'm attempting to do. Thank you, Madam Chair.
Thank you, Director. All right. Committee, I don't see any additional public comment or any agencies. Oh, maybe looks like maybe we do have a hand raised. Looks like we have Mr. Odakoven. Oops. Coming in. Mr. Odakoven, bear with me here. There you are. Welcome, Mr. Odakoven.
Thank you, Madam Chair. Greetings on the first day of February as we start our committee meetings. It's hard to imagine it would be February 1st when we were doing this, but we're getting started. We'll get some bills worked. If I may, let me offer a couple of comments touching on parts that were mentioned earlier and provide part of a text, if you will, to eligibility within the program. So I think it's important for the committee, especially the new members, to consider how does one get before the judge for consideration to the boot camp in simple terms. So as part of the pre-sentence investigation, the defense and the prosecution both approve of the pre-sentence report, and in that pre-sentence report from probation and parole would be a recommendation that this person would be best served by going to the boot camp or involving the boot camp at some point in that sentence outline. And that hearing, that sentencing hearing, is before the judge, and the judge would hear arguments pro and con and also decide that it is in fact in the best interest of the defendant to participate in the boot camp program. So it's not a decision that's taken lightly. It's not a decision rendered by someone far away, so to speak, from the case. It's by the court of jurisdiction, by the attorneys involved, looking at the defendant for that suitability. It fits the general, and I appreciate the good director's comment on what we affectionately refer to as early intervention. The sooner we can intervene with a youthful offender, provide that framework for that life-changing moment where they decide that a law-abiding life is better than a life of crime or of errors, omissions, and mistakes, as we described earlier, then our likelihood of being successful in integrating that person back into society, and as the director said, in 5 years, they'll be living next to you. So it would be nice if they were of a different mindset when they return to the community. Cost benefit? Yeah, not sure how to touch that, so to speak, because it's a duty upon the government to remove these people from society, to rehabilitate them if at all possible, so that they prevent the likelihood of committing that criminal deed or another criminal deed in that neighborhood where we live as well. With that, Madam Chair, I would answer any questions.
Thank you, thank you, Mr. Odakoven. Great to see you this morning. Questions for Mr. Odakoven from the committee? Mr. Odakoven, just for clarity, is it you support the bill?
Madam Chair, yes, ma'am.
Thank you, Mr. Odakoven. All right, appreciate your comments this morning. Committee, I don't think there is any public comment now for real this time. So Mr. Odakoven, thanks for standing by. We'll close public comment, and committee, back to you. Discussion on the bill, amendments to the bill.
I would move, we move the bill.
Moved by Senator Cost. Is there a second?
Second.
Seconded by Senator Kolb. Roll call on the bill.
Okay, this is a roll call vote on House Bill 34, Youthful Offenders Program Amendments. Senator Cooper,
Aye.
Senator French,
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
Chairman Nethercott.
Aye.
5 aye votes.
All right, thank you, Ms. Shippen. Senator Kolb, you'll carry this bill on the floor. I do, not knowing the full schedule for the days, you might be carrying it this afternoon, if not tomorrow, I would suspect. So be prepared. One tip that you could do is if you wanted to reach out to the Director Shannon, to get additional information, you certainly can, but the committee is here to help you present the bill and answer and field any questions, but you'll present it on the floor, Senator Cole. Yes, Senator Cole.
Is there a script, Chairman?
There's no script.
All right, well, thank you. I'll follow the good Senator Cooper's example and do my best.
It's because I'm so good that you think I always have a script, huh?
Well, that must be, yes, that is the answer.
I thought that could be the case. All right. Well, with that, committee, we're going to go on to House Bill 42, the Chancery Court Vacancy Amendments. We have a number of folks here to speak on this bill, and I'm going to bring them all in right now, so just bear with me as we bring them in. All right, committee, for this bill, I won't pick on Senator Cost, nor will I require you to listen to me again on this bill. This is a bill that did come out of the Select Committee on Blockchain, Financial Technology, and Digital Innovation, very exciting committee. And it's for the Chancery Court vacancy amendments. To back up a little bit, we have members of the Supreme Court here to present, and we'll introduce them here in just a minute. But in 2019, the Wyoming Legislature created the Chancery Court. And so what is a Chancery Court? A Chancery Court is a court of limited jurisdiction, really associated with civil transactions or civil cases associated with generally the business world, so corporate disputes primarily. You may know or may not know that Wyoming, in its efforts to diversify the economy for the last 150 years, did create the LLC and was the first in the country to create the concept of the limited liability company. And we did that in 1977. So pretty profound at the time. What often happens to Wyoming is our other sister states, or cousins in this case, steal our laws, and the state of Delaware did that. How many of you are aware that Delaware is the leading corporate place? Senator Cooper is nodding his head. Senator Cooper, how do you know that Delaware is the leading state for corporations to be domiciled?
A little bit of research, but when you start really looking at the history of so many corporations, you see it's a Delaware corporation. So it's just common sense, I think.
It is common sense. We just kind of accept that that's the way it is, right? That most of these corporations are domiciled in the state of Delaware. But how did that come to be? And it really had to do with those legislators in the state of Delaware beating us to the punch. And so not only did they steal our LLC law, they also created a Chancery Court and had that in place at the time. And so a number of LLCs became domiciled in that state and then proceeded to litigate their disputes in that state through their Chancery Court, which was an expedited, highly sophisticated business transaction dispute court. And so Delaware created case law and precedent there that allowed for stability and predictability in how business disputes could result. So it created the legal framework for the creation of those corporate entities, and then also how those disputes would be resolved. And so the Delaware courts are highly precedential across the country for creating the law and the baseline legal understandings associated with these business disputes. So Wyoming, despite creating the LLC, did not create a Chancery Court. And that's one of the reasons why I think Delaware excelled, because Delaware is just one of those little insignificant New England states, right? Just like we're one of those big flyover states. So they beat us to the punch. As you know, Wyoming has been pretty progressive in advancing financial technology laws associated with virtual currencies and establishment of special depository institutions for the ownership, regulation, and control of those custody assets. And so we wanted to side by side create the Chancery Court, allowing for many of those disputes to take place. And so we created that Chancery Court. The challenge was we have a funding issue in the state, and that's what this bill is in front of you now, is the realities of the funding situation don't allow the Chancery Court really to get stood up in a meaningful way at this point in time. So that's why this bill is in front of you. It's also why the Blockchain Technology Task Force looked at the bill. One, the Judiciary Committee's timeline didn't quite work out with the need to readjust and redirect the goal of the Chancery Court at this time. And there's a significant number of lawyers that sit on that Blockchain Task Force Committee, both from the legislature and in the private sector, that provided expertise on the bill. So committee, before we turn it over to public comment and to the members of the Supreme Court staff, any questions? Senator Kolb.
Thank you, Chairman. On page 1, line 12, the change from 2022 to 2026, what drove the change to 2026? What were the facts behind that being presented as it is? Thank you.
Thank you, Senator Kolb. Primarily, it's money. Just money. And just the need to buy some more time. So trying to come up with alternate, so we put them on a rocket docket. We tasked the Wyoming Supreme Court and its administrative staff with standing up the court in its entirety, and it did so at breakneck speed, with really the desire to get us operational as quickly as possible. We understood that there would be costs associated with it, but I think there was maybe some different concepts associated with what the Chancery Court would look like and what would be required to stand it up. And I don't think that's been particularly clear for the Supreme Court, necessarily hearing different thoughts and ideas from members of the legislature. But what we do know is that we're out of money right now. And so we just thought we would buy some time, put the brakes on the process to allow us to reevaluate and maybe refocus on how we can stand it up the most efficient way possible. And there's been a number of years present in this bill. If you looked at the engrossed version as opposed to the original version, looks like the House did some activities over there. And we'll let the Wyoming Supreme Court walk us through what the House did. This is all just a matter of legislative posturing for what the right time is. So with that, good senators, I'm going to turn it over to the Supreme Court. I'm going to start with Ms. Butler. If you'd please introduce yourself to this committee, Ms. Butler. It's great to see you this morning. Please share with us your thoughts on the bill.
Good morning, Madam Chair, members of the committee. My name is Elisa Butler. I'm General Counsel for Court Administration at the Wyoming Supreme Court. Just to give you, and I will let Ms. Munger speak to what happened in the House because she was able to listen to that hearing and I was not. But just some background on the bill, a little more about what we've done for the Chancery Court since the legislation was passed at the Supreme Court. So the legislation was originally passed in 2019 to stand up the Chancery Court. Justice Kate Fox was appointed as chair of the committee for the Chancery Court here at the Supreme Court to move that project along. She, as is her due, has done a fantastic job of getting that moving forward. There are a few things that the court has done during the time that we've been waiting to get it stood up. We've entered into a few contracts for a case management system, which is basically the record system that the clerks use to keep track of the cases that come through that court. We've also entered into a contract for an e-filing system. So we have been working on configuring the case management system, and the integration between the e-filing system and the case management system is anticipated to be done by May of this year. And then we anticipate that our schedule to basically start accepting filings in the court is December 1st of this year. So we are on track to get the court stood up. At this time, because of the, I guess, the timing of the bill and what it provides to appoint a dedicated Chancery Court judge, the legislation also allows for district court judges to act as a Chancery Court judge until the time that a permanent Chancery Court judge is appointed. And so the district court judges have really, come up to the plate and done their part in terms of making, sure that we have a Chancery Court and that we can move it forward, even if we don't have the budget for a full-time Chancery Court judge currently. So there's a panel of judges district court judges who will act as the Chancery Court judge. until a full-time Chancery Court judge is appointed. So that's kind of what we've done. Additionally, the Supreme Court adopted rules for the Chancery Court in accordance with the legislation. I believe it was by January 1st, 2020. So they adopted initial rules, then they allowed the bar to comment on those rules. The Chancery Court Committee just held a meeting last week to go through those rules. And so we anticipate that there will be a few amendments, and that will go to the court. They will make a recommendation to the Supreme Court, and then the Supreme Court will look at those and likely adopt a few amendments in the next little bit. So that's just a little bit of history on what the Supreme Court has done. Like I said, Ms. Munger and Ms. Smith have additional information that you all may find helpful. Unless there are any questions, I'm happy to answer any questions.
Thank you, Ms. Butler. Appreciate hearing from you. Committee, a couple of things to take note of when you try to find your bill draft, and you go to the bill detail from our committee meetings. You can click on the introduced bill, which provides the page number and line numbers of the bill. And then if you look below that, there's a link to the engrossed version of the bill. That's the version that's currently underway, as amended and going through the process. It's engrossed. And so the bill that we're currently working from is the engrossed version. So the introduced version had the date of 2026, and the engrossed version has the date of 2023. So just some point of clarity there. Does everyone see that on their screens and is able to find those bill drafts? Please nod your heads. If you can't, that's okay. We've got plenty of time. All right. Thanks, committee. All right. Any questions for Ms. Butler? Seeing none, we'll go to Ms. Munger. Ms. Munger, hopefully you can give us some insight as to what that House did to this good little bill. Welcome, Ms. Munger. If you'd introduce yourself to the committee.
Thank you, Madam Chair. Good morning, members of the committee. My name is Rhonda Munger, and with the retirement of Lily Sharp, I was named Acting State Court Administrator by the Wyoming Supreme Court. I guess before I speak to the changes in the testimony in the House, I'd like to say that the Wyoming Judiciary stands ready to implement the Chancery Court. It will kick off December 1st of 2021, regardless of the date selected in House Bill 42. As Ms. Butler explained, we have a panel of district judges, and through e-filing, they will begin taking cases in December of this year. There was a lot of discussion in the House as to how far out the date of the Chancery Court and the appointment of a full-time staff for the Chancery Court should be. The date in this bill will represent the date when we hire a full-time judge, a clerk, a staff attorney. There's one position that will be hired before then, but fully standing up the Chancery Court is what this bill timing is about. There was a lot of discussion in the House about how far out that should be and how much money would need to be spent getting it up and running. And I would say the majority of the discussion was based on the fact that the Supreme Court is ready, that they didn't want to lose momentum, that the state needs the diversification of its revenue streams and more business. And so ultimately, the 2023 date was adopted by the House. One other comment I would make, there was some discussion in the House about the district court clerks and their support of the Chancery Court. And Madam Chair, I would like you to know that the district court clerks have been very helpful in working with the Chancery Court Committee and working on the filing process and the logistics of getting this court up and running. And we want to thank them as well as the district judges for their help with this. It has been, as you explained, a rocket process, but we are ready. And with that, I will answer any questions you might have, Madam Chair.
Thank you, Ms. Munger, and congratulations on your new position. I
Thank
do
you.
appreciate hearing the participation of the district court clerks. You saw me grin there, as you know my perhaps skepticism, but I do appreciate hearing that. Questions from the committee for Ms. Munger? Senator French.
Yes, Madam Chair. Ms. Munger, so I can wrap my head around this, how does it help the court system by hiring a Chancery court judge or going down this path? What's the real benefit? Does it help unclog the court system? I'm naive on some of this stuff. So if you could help me out, I'd appreciate it.
Madam Chair, Senator French, and I will have Elisa Butler jump in here if she wants to add anything to this conversation. But so right now we have a panel of district judges that are going to hear these cases until this court gets up and running. And as the caseload grows, it will become very difficult for the district courts to handle all of these cases. As it stands now, the workload of the district court bench shows that it is approximately 3.5 judges short statewide. And with the increase of these kind of cases and the fact that the cases are to be heard in such a short period of time, right? So much like criminal cases and juvenile cases, the statutes for the Chancery Court require that the cases be heard in a very fast time frame, and therefore, as the workload grows, it will be difficult for the current sitting district judges to hear those cases in a timely fashion and meet those deadlines. And so eventually it'll be necessary to have a judge or a panel of judges, whatever the legislature decides, to hear the cases so that they can be heard in the very short time frame.
Thank you, Ms. Munger. I also think it's important, Senator French and members of the committee, to understand that this was not an ask of us by the Supreme Court or of the judiciary. So this isn't a state agency or entity coming before the legislature asking for something. This is completely a creature of the legislature. And the conversations originating out of this started back under Governor Mead's Endow task force, where a Chancery Court was identified as one of the tools or mechanisms that would help facilitate the diversification of our economy. It just so happened to kind of parallel and dovetail in with the work of the Blockchain Technology Task Force. So the question of whether or not we should or shouldn't have a Chancery Court has already occurred, and it already exists as a result of what the legislature did in 2019. So what this piece is really just kind of understanding the timing of those additional requirements associated with funding. And so that is it. And any member of the legislature can sell to you the benefits of why we need a Chancery Court. So again, I want to go back and where I started from, just to make sure this is clear, because Senator French, you're going to present this bill on the floor. So is that we really are trying to find ways to diversify the economy, right? Those are sincere pieces, right? Without having to come up with taxing measures. So how do we attract businesses here? And it is through we have a pretty aggressive and solid corporate filing system through our Secretary of State's office. We make a significant amount of money on corporate filing fees, primarily LLCs, right? Because our LLC law is so favorable to the creation of them and the autonomy associated with them, which of course is a whole other policy discussion. But the reality is we have significant amount of corporate business here, which Wyoming reaps the financial benefit from as a result of legislative work of us creating corporate structures. It really is that simple. The legislature can be proud in 1977, and the fact that we haven't jacked with it since, of its creation of the LLC, which brought in revenue to Wyoming without having to create a tax. So that is brilliant. But where we saw we were deficient and didn't quite become what we hoped to become is that Chancery Court piece in Delaware. I mean, if you really step back and go, what does Delaware have to offer? mean, honestly, what does Delaware have to offer? It's smaller than Fremont County where I grew up. It's tiny, it's insignificant, it's nothing. It's not Boston, right? It's not Washington, D.C. It's not any New York City. It's Delaware, Dover. Come on. So how did they become this place that Senator Cooper knows? It's just how it is. It's just where the corporations are located. Well, it's because their Delaware legislature created, corporate structures just like that they stole from us and created a Chancery court. And the significance of that Chancery court can't be understated. And as members of the Judiciary Committee, it's important to recognize that even as a young law student who had no idea about the sophistication of corporate disputes, knew that if I was going to cite to a case in my Wyoming court, I was trained and taught that it would be totally appropriate for me to cite to a Delaware case first, as opposed to even a Wyoming case, which is, you always cite to the law that you're in, the law of the state that you're in, except for Delaware when it comes to corporate litigations, perfectly fine to do that. So Delaware became a state of precedent nationwide. So not only is that the case for Wyoming, but if I was an attorney in California, it would be totally appropriate for me to cite to the case law of Delaware when it comes to determining business disputes. And I can't, undermine the value of that. That Chancery court, they have huge filing fees in that Chancery court. So you pay big bucks to access that Chancery court. So, and then every time you file a document in there, you pay more big bucks. And the reason why you want to pay those big bucks is because that Chancery court is highly sophisticated. That's all they do is resolve business disputes. And they're able to do so efficiently and fast. And so if you're a corporate entity, you know that years of protracted litigation is painful and arduous and costly. But even for paying big filing fees, you can get a resolution to your dispute fast, and that's worth time and money, right? And so they're willing to pay it. And you also encourage and attract more businesses coming in because you have the precedent, you have the playbook for how any disputes are going to be resolved in that state. I hope that makes some sense. So how that dovetails into the blockchain task force is we were first in the country to recognize virtual currencies, to recognize virtual currencies' role in the commercial marketplace, particularly under the Uniform Commercial Code and their place and application there. We were the first in the country to create a bank, essentially, the special purpose depository institutions. I mean, the first in the world to do this. And so we are attracting those entities currently underway. The banking division has approved 2 of those, and there's at least 3 more currently pending that have real brick and mortar locations here in Cheyenne. And of course, the brick and mortar is important to us, but so is those fees that are generated as a result of them being here as entities and are able to access all of our court filing systems and our Secretary of State's filing systems. And they're able to do a great deal of it remotely as well, but we still are able to profit from it. And that's the idea. So it dovetails very nicely into all of those significant efforts that have been underway to advance the financial technology space. You can tell I've worked a lot on it. But it's pretty profound. It's pretty profound. And hopefully it works. Hopefully it works. So again, we're not deciding on whether or not we should have a Chancery court. That decision's been made. It's just kind of allowing an additional speed limit associated with standing it up. So Senator Kolb.
Thank you, Chairman. I'm confused about the fiscal note or lack thereof with this bill. I mean, on one hand, we're saying it was the date of implementation is what we're talking about, and there's no fiscal note, so I don't understand what the fiscal impacts are. Maybe you could help me with that. Thank you.
Ms. Munger?
Madam Chair, Senator Kolb, with that, I'll turn this over to our Chief Fiscal Officer, Claire Smith, who can speak to this and the fiscal note as she prepared it. So Claire, if you would answer Senator Kolb's question, please.
Madam Chair, members of the committee, I am Claire Smith. I'm the Chief Fiscal Officer for the Supreme Court here. And I too find it interesting that there isn't a fiscal note. I did not receive a request for that, but there is, of course, a fiscal impact to delaying this a year. So when I look at the savings that would be generated by this delay, what I'm looking at is the reduced budget we would need for budget fiscal year 23, because we would only have a judge in place for 16 months, not the full biennium. And because as the statute stands right now, with the year 2022 as the date to fill this position, we would have some expenditures this year. So delaying this 1 year gives us some reversions from the current biennium, and then a reduced amount of budget for the next biennium. And that total is approximately $300,000. I've made a number of assumptions in coming up with that as far as other staff positions. But at a high level, we'd be looking at about a $300,000 savings for a 1 year delay.
Senator Coe.
Thank you, Madam Chair. What's the cost of the program then? If we've got a $300,000 savings, if the program wasn't implemented, I mean, this part is critical to me. I mean, the whole conversation's about why we're delaying it, and because of a fiscal issue. So in balance, what are we talking about when it comes to cost of program, even though we have some savings because we didn't fully implement it? Could you help me understand that? Thank you.
Ms. Smith, and perhaps you can also address the appropriation that was provided with the 2018 legislation as well.
Okay. Madam Chair, Senator Kolb, the entire cost for Chancery Court, we are estimating it's going to be just like a district court. There'll be a judge, there'll be a law clerk, a judicial assistant, and then depending on how we do this, there'll be either a court reporter or a clerk of court. Now, until the filings are extensive enough, some of those positions won't be filled right away. But at full capacity, we estimate that the cost of this court will be much like a district court, which is approximately $1.1 million a biennium. So in response to Chairman Nethercott's question on the current appropriation, we did receive approximately that much for the current biennium. During budget cuts, we identified that we had received funding for all the positions, even though we knew we would not be filling them right away. So the Joint Appropriations Committee reduced our budget. They cut it in half. So right now we're at about $567,000. So when I'm talking about the savings moving forward, that's based on a current budget of $567,000. So if we were not to extend this date, our budget for the next biennium would be approximately $1.1 million. If we delay this until 2023, the budget for our next biennium will only be about $900,000. We won't have that full $1.1 million until budget fiscal year 25, when we have a full 24 months of a judge in place. Does that answer your question?
Partially, thank you. How much revenue are we expected to generate from this activity of having a Chancery Court? Do we have any idea to offset costs? Or maybe that's not the point, but I just wondered. Thank you.
No, Ms. Smith, I'll let you answer. The answer is we have no idea, right? None whatsoever. So, hopefully, and I think when we understand when it will generate revenue will be a significant amount of years out, meaning like 5 to 10 years, if any. But the idea is for it to be predominantly self-sustaining. So originally in the original bill draft, there was a $1,000 filing fee. So in order to initiate litigation, to file that first lawsuit, you had to pay $1,000 just to access the court, as opposed to our district courts, which the filing fee goes up every year. I think right now it's like at $130, $135. I say that with a level of sarcasm because, we got to do $1 a page to email file, but it goes up at least $10 to $15 every year since I've been in the legislature. So I think in order to file a lawsuit in the district court, it's like $130 compared to that $1,000 Chancery Court filing fee. So you can see the difference there for how part of that funding can be managed or maintained. Now, will it be completely self-sustaining? Probably not for a while. But that wasn't the idea. And the other piece I think is important to think about is understanding the complexity of it, self-sustaining as it relates to the court, or looking at the revenue generated through corporate filing fees and other revenue generating concepts into our state, as opposed to just the court system itself. Ms. Smith, do you have anything to add to that?
Madam Chair, no, I do not. You hit it on the nail.
So when it comes to the special purpose depository institution, or the Speedy Bank, which is regulated through the banking division, they collect fees associated with those chartered banks as well. You know, so are we going to compile, are we going to, you know, if you limit it just to kind of the fintech space, how much money we can generate in to justify the creation of the Chancery Court? Probably. In a matter of 5 years, it'll be worth it, but that doesn't mean all the money is returning into the Chancery Court itself. You know, and the Chancery Court can also deal with other types of disputes other than just fintech. It can do, you know, your complicated family ranch dispute for, you know, trust, and the kids are fighting and there's mineral disputes on it and it gets messy. It's designed to deal with that as well. So it can deal with some of these traditional civil disputes that we have in Wyoming on a faster pace. So Ms. Smith, I'm curious to know what date you think is appropriate in your opinion. Don't be afraid to tell us.
Madam Chair, members of the committee, we will do whatever the legislature wants us to do. You know, the district judges have been, they recognized that they were not able to contribute much to budget cuts because their budgets are just so bare bones. And so they graciously offered to cover these cases for a while. Naturally, they're not going to be able to do that long term. They're, as Ms. Munger mentioned, they're already too few judges. And as the pace of this picks up, it's just going to get busier. So I don't have an opinion on that. Whatever you want us to do, we will get it done.
Any comments, Ms. Munger, Ms. Butler?
No, Madam Chair. Thank you for the opportunity to speak today.
I guess it's smart. All right. Well, any final questions for our Supreme Court administrative team? All right. Seeing none, thank you so much for being here. All right. With that, we will close public comment. We're back on the bill committee. Discussion on the bill or any amendments? Currently, the bill that we're voting on has that 2023 date. That's the bill currently in front of us. Senator Kolb?
Yeah, Madam Chair, I think you're uniquely qualified to comment on this because you are a practicing attorney and you understand, I think, the ramifications of having this long-term and short-term. So I guess I would like to hear your opinion about these dates because I'm going to listen with great interest. Thank you.
Thank you, Senator Kolb. I think the 2023 date is fine. And probably a little hard for the new members to kind of keep up on. The legislation was passed and it's been worked pretty heavily since. So the Supreme Court has done a pretty phenomenal job on, you know, just immediately getting up to speed on all the things that they need to do. The Joint Appropriations Committee has been paying close attention, the Blockchain Task Force close attention, and the Judiciary Committee has been paying close attention. And so as a result of, I think, those proactive relationships on the Chancery Court, I think we're fine with whatever date we put in here, and it will probably be revisited annually for quite a while. And that's appropriate because it's kind of an ever-changing, it's a dynamic situation, right? We're starting this new program. And so, you know, we quote unquote, arguably fully funded it in 2019 with that $1.1 million appropriation, but it probably was an overkill, right? Because we actually didn't have the positions to fill at the time, nor did we have the need for full-time positions associated with the court, but we will, right? So it's as a matter of kind of the timing of standing it up and needing to have an appropriate budget associated with it. while parallel with that would be it generating revenue as well. And so as we continue to evaluate it, I think it will need to be tweaked pretty regularly. So I'm comfortable with the 2023 date. Senator Kolb?
And just to follow up on that, so all unexpended monies go back in the general fund. That 1.1 million that was set aside, they won't use it totally in this biennium.
Senator Kolb, I don't know where they are on they have entered into contracts where they have used some of those funds. The Joint Appropriations Committee cut their budget in half. I think took 600,000 back from them as a result of their inability to use it just for where they were on starting up the program. But you heard testimony that they have entered into contracts for the creation of that electronic filing system for the Chancery Court. And so I do think some of those funds have been expended associated with what does need to be taken place now. So I don't think any money is intended to revert back to the general fund, but their budget was cut and that 600,000 went back somewhere. I don't know exactly where it reverted back to, but we'll call it the general fund. Senator Cooper?
I see a real need for this Chancery Court to move forward. The 2023 date, that's when they have to be up and running by this statute. Is there anything preventing them from being up and running sooner?
Senator Cooper, that's a great question. I think the answer to that is no. I think it really is just the logistics of understanding what goes into setting it up. Senator Cost?
I think we need to move the bill.
All right, moved by Senator Cost. Is there a second? Seconded by Senator Kolb. Discussion on the bill? All right, seeing none, roll call vote on the bill.
This is a roll call vote on House Bill 42, Chancery Court Vacancy Amendments. Senator Cooper?
Aye.
Senator French?
Aye.
Senator Kolb?
Aye.
Senator Cost?
Aye.
Chairman Nethercott?
Aye.
Madam Chair, there were 5 aye votes.
Thank you, Ms. Shippen. All right, Senator French, you'll carry the bill on the floor. Again, you'll have the committee to back you up. And as a reminder, you might be presenting it later today or tomorrow. All right, with that, committee, we'll go to our final bill of the day, which is arguably one of our most important bills of the day. And that is House Bill 35, the Theft Statute Amendment. It appears as the committee, let me go back and just I'll explain this bill. In 2019, the interim Joint Judiciary Committee took up as part of its interim topic, as you've heard about, the review of Wyoming Supreme Court opinions. One of those cases identified the need for the legislature to look at revamping our theft statutes with the suggestion that we look to how Colorado consolidated their theft statutes. And so the committee took that work up. And we did consolidate all of our theft-related statutes. No substantive changes were made to the laws. So we didn't change what it meant to steal. We didn't change the financial thresholds associated with theft. It really was just a consolidation and a reorganization of how the theft statutes operate and worked. It was robust legislation. I don't remember the page numbers, but it was significant, which should signify how complicated our theft statutes had become over the course of time. The bill was perfect when it left the Joint Judiciary Committee and was perfect when it left the Senate. Unsurprisingly, the House did an amendment and completely killed the entire bill. And it was something that happened at the very end of session in 2020. And it was not caught by either LSO or any legislator. And what it did is it deleted the word or. And the result of the deletion of the word or resulted in the entire statutory framework being moot and unworkable. So when you don't have the word or, a statute is read to mean and, essentially. And so you had to have all of these elements take place before someone could get charged and convicted of it. So it really has been a terrible thing for the state of Wyoming and prosecutors and law enforcement across the state, because the law is completely unworkable. It's really bad. I can't overstate that. So the Joint Judiciary Committee, when it became aware of this error in our statute that resulted, we immediately went to work to replace it. And so when you look at the bill draft, the word "or" has been added back in. And it really shows the significance and the level of technical detail required to how we work and legislate, and how even at the very end, when we're all exhausted and tired, the importance of paying close attention to even words like "or." When I look at the published legislation for House Bill 35, all I see is the introduced version of the bill, but it does appear that amendments were made on the House side. And so we don't actually have the engrossed version of the bill. But if you go, you can find what actually happened. And I would like to see you working on your computers to go find that engrossed version, to find those amendments associated with the bill draft that came out of the House committee. So if you're on House Bill 35 and you look at the tab that says amendments, you can see 3 amendments that have taken place. There was the first amendment, which was the standing committee amendment by the House Judiciary Committee that was adopted. There was a second reading amendment by Representative Stiff that failed. And there was a third reading amendment by Representative Stiff that is unclear to me where that is. Ms. Shippen, do you happen to know, or do you have any updated information on the status of these bills, of this bill?
Chairman Nethercott, I just received a message from LSO Legal that they don't believe this bill has passed the House yet.
Okay. Well, thank you so much. That's very important information for us to have. We actually should not have it in this committee yet. So, but committee, this is actually one of the most important bills for the legislature to review this year, quite frankly. I sent it to the House as one of our joint judiciary because it's an easy bill. I'm a little disappointed to see all those amendments taking place on the bill over there, because I'm hopeful that no further activity or actions is done on that particular piece of legislation, because all we needed to do was add the word "or" back in. And so I'm really disappointed to see the efforts on the House side. And I anticipate we'll probably strip it all away when it gets over to the Senate and really just keep it back to its sincere and purposeful form of just making that simple correction, as opposed to trying to jack with that bill again. So if there becomes a time where this bill does pass out of committee and we have the ability to meet again, I'm going to ask that we do that as urgently as we can, because it's really important to our criminal justice system that this law gets remedied as quickly as possible. It's a simple fix. It's an embarrassing fix on behalf of the legislature that this happened. And I am just committed to getting it remedied as quickly as possible. So there's no action to take on this bill, but my point of that is I want you to listen to me clearly. When you hear the president read out and report to committee number 1, House Bill 35, I will have a meeting set as quickly thereafter. So you'll need to pay close attention to when I'm going to set that meeting to hear this bill, because I'm hopeful that we'll be able to get it out as quickly as possible. It really should take this committee 5 minutes to look at, to understand we need to add the word "or" back in, and that's it. As you can see, there's no public comment on this bill. There's nothing to discuss. It's just to get it corrected. So, I'll want to move fast to get it done. So I'll need you to be on the ready to make sure that we're able to get this finished. Questions about that? Senator Cost?
Yes, and at the same time, unless something is favorable in their amendments, I would probably ask that we remove their amendments from the bill.
Yeah, I think that's probably
I
that.
would make that motion.
Well, we don't have the bill currently in front of us now, so we can't work it. But when we do get
I
it,
understand that, but when it comes up, I'm
we'll
saying.
probably do that. Senator Kolb?
I'd just like to state for my co-senators of this committee that I have an affinity towards the word knowingly and like that word tremendously. Thank you.
Yes, the good Representative Stitt does too, as do I. So the word knowingly in the criminal law actually is a really important word. So it actually is a term of art in the criminal law. As you can understand, when we make crimes, there's a concept that we call mens rea, and that is what your mental state is at the time. And that goes to your levels of intent. And it's most easily understood in the concept of homicide because we're just familiar with that. So you're all familiar with the different levels of homicide, right? Senator Kolb, what's the difference between first degree homicide and manslaughter?
First degree would be knowingly laying in wait. Manslaughter would be more of a, frankly, I'll say it as an accident that had happened and caused someone's death.
Yeah, I think that's a fair, just common sense understanding, right? We know that first degree murder means there was no question that you intended to kill this person, right? Where a manslaughter charge was you didn't intend to kill that person, but they did die as a result of your actions. And so there's a huge distinction between those. Then we have various degrees in there as well of the different types of intent associated with that. And knowingly is that kind of first degree level. There's knowingly, recklessly, negligently, those, and then there's intentionally, even on top of that. Intentionally, knowingly, recklessly, negligently. Those words are terms of art in the criminal code. So when you see that word knowingly thrown in there, it means you're changing the standard of proof. You're changing an essential element associated with the crime underlying that particular offense. So theft typically is considered what we call a specific intent crime that requires you to have the intention of stealing, right? Because how many times have you taken something that belonged to you by accident, perhaps? Yeah, I mean, it happens, right? You grab the wrong iPhone, you grab the wrong laptop. All of our laptops look similar, right? It wouldn't be unreasonable for you, but it doesn't mean you had the intention to steal it. Now, should you have known, maybe, if it had somebody's name right on the top? Maybe, and all of that comes to levels of degree and proof and discretion. So, what's important to understand is wrapped up in this theft statute bill, and I'll email you the original version of the bill, is concepts associated with horse rustling, defrauding an innkeeper, embezzlement, classic larceny, all those types of ways that we can steal, including gasoline, that get pretty complicated in reality on the ground. So I, again, just want to urge caution as we think about this particular bill draft coming in front of us. I'll speak with the good House Representative Stitt about his concepts that he's trying to continually add in over there on the House side and see where that leads us. And again, one just piece of caution is that the whole idea of the original bill draft and the judiciary's task wasn't to change the law, but really was just to consolidate it in a more effective tool within our green books. So any questions that we've talked about today on criminal code, Department of Corrections, Chancery Court? All right, seeing none, committee, when are we going back into session? 1 o'clock. All right, sounds good. If you have questions, please feel free to reach out to me. With that, committee members, this meeting is adjourned.
Chairman Nethercott?
Yes.
I just want to make sure before you leave the meeting that I can confirm the 2 votes with you that we did have. The vote on House Bill 34, Youthful Offender Program. Pardon me, let me turn off our live. Let me end our live feed.
Sure.
All right.